Okay, I'm gonna try this again. I get carried away. Alright, today I'm going to show you the motive, how they accomplish it, and why they're doing it. Okay, we're going to start off by letting you know that this is in the state's best interest. It is under 61-1826, Florida Statutes 1A. It is in the state's best interest to preserve the essential role of the clerks of the court in dispersing child support payments and maintaining official records of child support orders. It's in the state's best interest, not in your child's. Look up, I think it's 42 U.S.C. 656 1. And you'll see that it is an obligation to the state. It is not an obligation to your child. They substitute or subrogate the right, substitution of one thing for another, or one person into the place of another with respect to rights. It's called the assignment of rights. I think that's under 408A3, 42 U.S.C. 408A3. They have to assign the rights. No benefits for anyone that doesn't assign rights. So they are providing benefits to one person with control over another person to get the right. They're putting a third person into the place of another. That's false representation. Any person who, without authorization, fraudulently uses or possesses with intent to fraudulently use personal identification information concerning another person without first obtaining that person's consent. Well, that's what they do when they get you to sign a promissory note that they don't tell you. They tell you that it's just an intent to pay, but they cash that promissory note and use your credit to do it. Your kids never see that money. That money goes straight back into the child support enforcement. It is then used to pay these administrative hearing officers who I think I found it in Title V somewhere that they get the daily rate of a GS-16 employee of the government. I don't know exactly what a GS-16 gets paid. The highest that I've been able to find is a GS-15, but don't. You know, it's in Title V somewhere. I saw it somewhere. I can't find it right now. I didn't think it was pertinent to any of this, so I just left it alone. But yes, they do get paid by the day that they hold the hearings. And they fraudulently use your credit, your personal identification information to obtain your credit. Making a false statement to obtain property or credit. They're telling you you owe the obligation to your child. The obligation is to the state. 408A3, Title 42. They're making false statements in writing relating to financial condition of corporations, since the state is a corporation. And they do have a financial interest because they get paid to do this. And it's for the fraudulent intent of obtaining credit. You can find that in 81703. Freeze the video if you need to look all this stuff up. This is Florida law, but I promise you, we have one system of law in this country, and if there's a law in Florida for it, there's a law in your state. It doesn't matter if it's Alabama, Georgia, Mississippi, Louisiana, there's anywhere. Wisconsin, Alaska, there is a law in your state. Obtaining property by false personation. Well, I've already explained that if the obligation is to the state and they've subrogated the rights by putting their third person self, the state, into your business, they're falsely personating your ex-spouse, whose name is on every single ticket as a petitioner when you go to the family open business meetings. Don't even call them court, because it's not. It's open business meetings. And you don't have to participate. Challenge them immediately. This is not legal advice. I'm not an attorney. I make no claim to be an attorney. If it were me, this is what I would do. I would challenge them immediately. By what authority? Show me a proof, material evidence of an injury in fact. Show me concrete and particularized evidence of a proof of fault. They don't even have probable cause. They don't even have reasonable suspicion. What they have is hypotheticals, speculation, conjectures, which is guesses. I've gone all over all of that in due process. They are falsely representing another person, and in such assumed character they receive property, such as commercial paper products or dollars, intended to be delivered to that person. They then use that as a 25% hold in a bank account. It's the clerk of court's fractional reserve trust fund. But they receive your promissory notes, which is a negotiable instrument. You can look that up. I suggest you do. The promissory note is then converted from the collections account to the disbursements account, and then paid back to them and put into that fractional reserve trust fund that is monitored and maintained by the clerk of court, which is why it's in the state's best interest. They use it for their own personal use because that's how they receive their paychecks. That's called a misappropriation of funds because they're taking the money entrusted into their care unlawfully. All of this is unlawful. It is capitation, which is explicitly prohibited in the Constitution as a fee, charge, tax that is levied on a per-person basis. I mean, that's exactly what it is. They do this through coercion. Human trafficking. You can't get away from it. I mean, that's exactly what they're doing. They're providing benefits, and they're taking advantage of your position of vulnerability because you don't know what's going on, and any harm that's sufficient to compel directed towards any person. Such as force and fraud, which is coercive. In fact, they even call it coercive sanctions. When you look up contempt of court in a child support hearing in Florida statutes, they call it, they say in there that they're allowed to use coercive sanctions. What coercive sanctions to compel is manipulation of will. It's all a fraud. Just like this picture right here, it's a fraud. It's all being done under color of law. It's the appearance or semblance. It doesn't have a substance. There is no substantive issue. There is no injury in fact. There is no proof of fault. There is no invasion of a legally protected interest or a legal right. It's all economic, and economic has been proven in my due process that an economic is not enough to give substance to a claim. An economic interest alone is not enough to give substance to a claim. There must be some kind of a violation of a legally protected interest, such as the protection of your right to travel, the protection of your right to own property, to contract your labor. Okay, I got a little bit more. I'm going to start another video and try to get through it. Well, I'll show you one more. It's arbitrary. It's not supported by fair, solid, substantial cause. It is without a reason given. And the reason wouldn't matter anyway, because if they're saying they're doing it in the best interest of the child, and I've already proven right here, it's all in the state's best interest. They're lying. It's arbitrary. There is no substantial cause. Now, this is the administrative side. I'm not saying the judicial side. If you're in the judicial side, you must have done something that they had some kind of proof of fault, or at least a probable cause. which means you probably caused some injury. This is for the administrative side, business side, for-profit business side. I'll be back in a minute.